School is out for the summer, but one family is still focusing on school and a major issue that came to light. They've been fighting this for more than a year. So this is about the Barbers Hill ISD student who had a tumultuous school year because of his hairstyle. You might remember Darryl George. He wears his hair in locks. You can see it here, but he tucks them up in this sort of protective, neat style. They're not hanging down. He does this because he was told that his hairstyle didn't adhere to the district's guidelines. He's been removed from the traditional classroom, put in an alternative school, and an in-school suspension since last August. His family argues that this discipline violates the Crown Act, and they took legal action a few months ago. But a Texas judge said the district, Barbers Hill, can punish students without violating the Crown Act. Well, now George and his mother and their attorneys are looking to appeal that decision. Darryl's mother, Darryl George, and their two attorneys, Allie Booker and Dylan Drummond, are joining me now to talk about this case. I appreciate you all for joining us this morning, and I hope I sort of got that whole backstory right. I know there's been a lot of developments here.
You have it right.
And so, I mean, first off, Darryl, is he 18? I mean, should he be finishing school now, or will he have to go back to the classroom in September?
He go back in September.
He does. Okay, so tell us now, moving forward, Allie, can you talk to us about what is next? Because he goes back to school. I guess supposedly if there are no changes in this decision in the courts, he's going to be in in-school suspension or disciplined again, right?
That is what the aim is. That's what Barbers Hill's aim is. However, we will be taking action before that occurs.
Tell me what you guys are doing.
Well, I'll let Mr. Drummond speak about that.
Mm-hmm.
We have filed the instrument that kicks off the official appeal of the trial court's decision here. We have filed everything that we need to file to have that officially docketed, which it has been in the last 24 hours. You know, one of the primary grounds that we're going to be presenting to the appellate court is that both the school district and the trial court here have basically invented an exception to the statute, to the Crown Act, based on hair length that the statute just flat out does not contain. That exception here would actually invalidate the wearing of a protective hairstyle that the statute was enacted to actually protect. And so Texas law just does not allow that type of jurisprudential imagineering, and so we are going to present that to the appellate court in the hopes that they reverse the trial court's decision.
Yeah, and Mr. Drummond, I mean, if you can, for those of us who were not there in court and didn't hear all the nuances in what the judge said, I mean, basically, and correct me if I'm wrong, the Crown Act says that locks, dreadlocks, these sorts of ethnic hairstyles are protected, that students can wear them to school, but then Barbers Hill said, but locks can't hang below your ears, but then Darryl George's locks don't because he wears them up. But are they actually saying, but if he did take them down, it would violate it, so he's in violation? Is that the gist?
Well, yes. The language of the policy here is the same language that has been in place for several years now. It's the same school superintendent, the same school district that has taken these same types of punitive measures against other Black students in their district, which is currently pending. There are several actions pending both in state and federal court. Mm-hmm. The language of the policy itself says that that the length of the hair can't exceed a certain length when let down, and so that's how they have tried to get around the prescriptions of the Crown Act. But the fact remains is that the Crown Act does not, in its plain text, contain any exception for hair length. So the fact that the district or the trial court here wished that the legislature had invented that exception, it just doesn't exist. And so courts are not allowed to legislate from the bench and jurisprudentially rewrite statutes to create exceptions that are not present. So that's one of the fundamental grounds that we're seeking to overturn upon which we're seeking to overturn the decision.
Yeah, I appreciate that explanation. Darryl, I know you have to have talked to people, and it might sound like common sense, but explain to us, who have just said, like, oh my gosh, could you just cut your son's hair so he can finish school? Like, what is all this really about?
It's more than just his hair. It's more than just that. It's his whole identity. Why should he have to change his identity to get an education? We're not asking for much. We just want fairness, and it's not fair at all.
The protection of the law as it was enacted.
Yes.
And then one last question, Dylan. I understand that, these appeals, can't they take time? I mean, now we're talking about, just 2 months away, barely 2 months before school starts back again. Do we actually think that the court will take this appeal up before school starts back?
Well, the appeal is active and live now, but you're absolutely correct that for appeals to work their way through the judicial system, it can take a while. But that's exactly why we have kind of front loaded many of our filings here. We have plenty of time to file them under law, but we've gone ahead and filed all of those precursor filings now, so that we are not, so that we're taking full advantage of the few scant months that we have here here before the school year starts, and we are going to prosecute this appeal as vigorously and quickly as we possibly can.
All right, Darryl, Drummond, Allie Booker, and Darryl George, thank you so much for waking up with us this morning and explaining the latest developments in your case. We appreciate it.
Absolutely.
Thank you.